Live from the TV30 studio, here is Jim Schneider.
Well, good evening and welcome to inFocus. We're glad that you've joined us for the broadcast this evening. Ladies and gentlemen, this program is coming to you live on Monday, March 27th. We are 8 days away from a very critical election here in the state of Wisconsin. And early voting is already underway here across the state. Will be going on through the course of this week. On Tuesday, April 4th, the polls will be open from 7 a.m. until 8 p.m. And friends, with this many days, including leading up to the election, as well as Election Day itself, please consider that there is no excuse for not participating in this election. Very, very critical for you to be out and casting your vote. Something else I want to mention tonight is that you should not assume that the circle of people that are around you know about this election. And it's important for you to be informed yourself so that you can inform others that you come in contact with regarding the election and what's on the ballot and the significance of the election that's coming up on April 4th. Speaking of the ballot, though there is one statewide race, there are many, many other items on the ballot, other offices you're voting for. Some are voting on mayors, I think of Racine, for instance. Some of you are voting on school board seats. Some of you are looking at county board supervisors or positions that are taking place there. Everybody will have some referenda questions. Lord willing, Julian Appling will be back next Monday night on election eve. We'll be looking more at the ballot and some of the issues going on. But it's important for you to know what's on your ballot. How do you find out? The state has a website you may go to, and it is myvote.wi.gov, myvote.wi.gov. And you'll see some blue circles there. You can find out where to register. You can find out or how to register, where you go vote. But there's another one there called What's on My Ballot. And all you have to do is click on that button, and it takes you to a page where you just put in your address. And after you click the enter button there, you'll be able to see all the different offices that are on your ballot. And so you can go and be informed. And what happens, it happened to me, I look and say, wow, I didn't know I was voting on this particular race. So what do? Then I start researching the candidates, go looking at their websites, finding more information about those candidates so that as I vote, I'm able to vote with intelligence and information as to who the candidate is that would best represent the views that I would have. So use that and inform others about the importance of this April 4th race. Well, friends, on the office, as we mentioned, on every ballot is a position for a justice on the Wisconsin Supreme Court. This is a 10-year term to the court, and this is going to have a profound influence and impact upon this state for generations to come. We've been contacted by the Daniel Kelly campaign for an interview, and it's our privilege to have him in studio with us this evening. The Honorable Daniel Kelly, former Justice, Associate Justice of the Wisconsin Supreme Court, and now running for a 10-year term. Good evening. Good to have you here.
Good evening, Jim. Thanks so much for having me here. I really appreciate being on your show.
It's certainly good to have you with us. This race has really taken on a national persona. I mean, from news stations and commentaries from around the country, newspapers are talking about this, media all over. Why such significance to this race?
Well, I think because the choice before the people of Wisconsin is so stark. I think this is going to be an election like no other, and mostly because my opponent is a candidate like no other. I've literally never heard of or read of a judicial candidate who campaigns on a platform of putting yourself above the law. As you know, our entire governmental system depends on the premise that there is no one who is above the law. And that goes double for those who serve in government. And yet, my opponent comes along and says that it will be her political views and political values that decide cases. Well, that's putting herself above the law. So now my view of the office is the one that's described by our Constitution. So as I look at that, I understand that the people of Wisconsin look at us in the judiciary and they say, we've got one job for you. It's just this one thing. Pay attention, don't get distracted, just do this one thing. And that is use the existing law to decide the cases that come before the court. And they go on to say that they're not particularly interested at all in what we think about the law, whether it's good or effective. They say they've got an entirely different branch of government to answer those questions. That's the legislature. So I know the role of the court is simply being faithful to the Constitution, and in doing that, being faithful to the people of Wisconsin. Now, that's worlds away from my opponent's view of what the court is to do. She believes it's an instrument to advance her own personal politics. Now, the reason I think that is getting attention from around the country is because there are others around the country who are looking at this race and seeing if my opponent's gambit works here in Wisconsin, they're going to replicate that in states all over the rest of our country and try to push those courts in a more activist political direction.
So you were just really describing your judicial philosophy as compared to your opponent. Separation of powers is really important. And just give us a word about, because this is new information for some people. They did not receive the education in schools. 3 separate branches of government, each has their own function.
That's right. So we've got legislative, executive, and judicial, and I think probably the best way to grasp what each one of them does is to lay them out on a timeline. Each one of those branches has one piece of that timeline. So the legislature deals with matters of the future. And the founders understood, and the framers understood, that the legislative branch would be the most important branch of government. So they peer into the indefinite future, and with all of their collected knowledge and wisdom and background and education and experience, they try to figure out what laws will promote human flourishing for the state of Wisconsin. It's a tough job because nobody knows the future, but they get together, they try to figure out how that's going to work. So they deal with the issues of the future. The executive deals with matters of the present. So they look at the job that the legislature did and they say, all right, we will then take that law and we will apply that today. We will execute that law faithfully today and every tomorrow as it becomes today. So they get matters of the present. Now the court, there's only one spot on the timeline left. We get the past. Every case that we look at addresses something that has already occurred. Somebody didn't follow statute, they breached a contract, committed a tort, whatever it might be. We're always dealing with things that have already happened. And so our responsibility to preserve liberty and to preserve the rule of law is to look back and say, all right, what was the law that was in effect when those facts occurred? And we apply that law. So that's why we don't steal the legislature's authority. If we were to take the legislature's authority and create a new law, we would be applying that to something that had already occurred. And that would steal away from the people of Wisconsin the right to know what the law requires of them before they make their decisions. So that's the promise of the rule of law, is that we get to know what the law requires first, and then we can conform our actions to what the law says. So that's why, as a court, we have to keep concentrated on what the law already said about those questions, and we don't try to steal the legislature's forward-looking power and turn that to the past.
Tell us why you want to return to the court.
That's why, so 2 reasons, really. One, I understand that all the authority that we exercise on the court is borrowed authority. It doesn't belong to us. It doesn't even belong to the office. All that authority belongs to the people of Wisconsin. Now, that sets up a really important relationship between the people of Wisconsin and those who serve in government. And it's the relationship of boss and servant. And I know that I'm not one of the bosses. As I served the people of Wisconsin on the Supreme Court as one of their justices, I understood I was there as a servant. And the people of Wisconsin were my bosses. And Jim, I had the best bosses a guy could ask for. So in addition to that, I loved the work of the court. So, when I was going through the appointment process on the court, a friend pulled me aside one day and said, are you sure you want to do this? And I looked at him and I said, well, I think so. What were you thinking? And he says, well, you got to understand what this is going to look like every day. You're going to go into chambers alone, and every day you're going to be reading, researching, writing, and I'm looking at him going, yeah, this sounds great. So I love the work of the court. It is deeply fulfilling. And so I've gone around the state of Wisconsin over the last couple of years doing presentations on the proper role and function of the judiciary within a constitutional construct. When I get done, so many people have come up to me and said, we want to make sure that our next justice on the Supreme Court is one who is committed to the Constitution, committed to the rule of law, and we want to know for certain that that's what he's going to do. And they say that we see that in you, so would you run? And so as those invitations piled up over time, eventually my wife and I, we prayed about this. We thought long and hard about it because we knew this was going to be a difficult path. But eventually we decided that we would do it, partly because just the greatest bosses, partly because it was a joy to serve in that capacity, but also because we need to preserve the Constitution in the state of Wisconsin. And as I was looking at what my opponent was saying even at that time, it became apparent that she was not planning to be faithful to our Constitution. She was not planning to preserve the rule of law. She wanted to institute the rule of Janet. And I think that would be disastrous for the state of Wisconsin. And so we've been committed to this race and making sure that we preserve the role of the court, we preserve the Constitution and the liberties that it protects. And I just think that's an absolutely essential thing to do. And that's why I'm running.
Justice Daniel Kelly with us here tonight on the inFocus program and talking about his candidacy here for a 10-year term. A reminder that April 4th is Election Day across the state of Wisconsin. Justice Kelly, how would you describe your moral compass? What guides you?
Yeah. So I guess where that starts is who you consider yourself to be in this whole world. And, you know, my parents raised me in the Catholic Church, and I love the Catholic Church to this day. But, you know, there's a point in time that everyone has to encounter where your faith becomes your own. And that point for me was as a junior in college when the gospel was presented to me in a very compelling way. There's a story behind that. I started hearing the gospel on a train between Irkutsk, China, and Beijing, or Irkutsk, Siberia, and Beijing, China. And so over that period of time, learning about the gospel and that salvation that is offered to us through grace captured me. And so I've been a born-again Christian since I was a junior in college, and that is the baseline for now everything that I do.
Right. When you were describing the different functions of government just a bit ago, and you talked about the future, the past, and the present, as you were referring to the past, can you point to any ruling that you've had to make that that you looked at what those laws were, and you said, that really conflicts with what my viewpoint is on things, but I have to stick by the law. Can you point to anything like that?
Yeah, I can. So, you know, and I'm really careful when I talk about this because I don't want to give away anything about what I like or don't like about the law, because that's not something that relates to the work that we do. But what I can say is that there are cases that I've decided where those who would otherwise be supporters really didn't like what we did. But the point was we still needed to follow the law. So one good example of it, I think, is the SEIU versus Voss case. And that dealt with a statute that was passed, I believe it was in 2018, and it dealt with guidance documents. So the executive branch issues these guidance documents, and they're a reflection of what the executive understands the law to require. And the legislature said, well, we don't like some of the guidance documents that the executive branch produces. And so we want to insert ourselves into that process. And so we're going to tell the executive branch, here's the way that you can adopt them. And here are the considerations you have to account for. And only after that can you adopt a guidance document. And so I looked at that and I said, well, you know, going back to the different branches of government, that may have been a prudentially good decision, but the question before us is it lawful? Can the legislature compel the executive branch to go through a certain process as it writes down its thoughts about how it understands the law to function? And we looked at that, and Justice Rebecca Bradley and I concluded that, well, that is a violation of the executive's authority. That is authority Constitution gives to the executive. And so we said the legislature, you know, although it may have been prudentially a good process that they laid out, they simply didn't have the authority to do that. So that's our responsibility as the court. When those kinds of questions come to us, is we have to privilege the Constitution over the statutes. If there's a conflict between the two, then we have to say that the Constitution comes first, and we have to enforce that first. And if a statute conflicts with that, then we can't give effect to that statute. So I know that there were those who were very disappointed in that opinion, because they liked what that statute would accomplish. And like I said, it may have been a really great idea. It just was the legislature didn't have the authority to do it.
Sure. There is anybody who's seen any ads, radio, television, whatever, look at the newspaper. Journal Sentinel has said this is all about abortion.
Yeah.
We see that take place. This is an email that came out from NARAL, Pro-Choice America. And in this email, they indicate this: Judge Protasewicz is an eminently qualified judge who's been a vocal supporter of abortion access and the freedom to decide. Former Justice Kelly, in contrast, is a Federalist Society judge endorsed by numerous anti-choice extremist groups who has written extensively about his opposition to reproductive freedom. How do you respond to that?
So first off, the question of whether what the law ought to be on that subject is a matter for the legislature to determine, right? So when we talk about the three branches of government, where we have our political differences and our political questions, we take those to the legislature and we resolve them there. The court is there to resolve only legal questions. So the first sentence of that is problematic because what NARAL is saying there is entirely contradictory. So they say that my opponent is eminently qualified because of her position on these political issues. Well, one of those parts of the sentence contradicts the other, because if you are vocal about your views on politics, that's actually a disqualification from office in the judiciary, because our role there is not to answer those political questions. That belongs to the legislature. And so this is another example of where my opponent and I are so vastly different, because I understand what the Constitution says that the courts are supposed to do, and she either doesn't understand or doesn't care what the Constitution says the courts are supposed to do. She wants to take the power of the legislature and then use that in our courts. And that is destructive of the constitutional order. It's destructive of the rule of law. And it would substitute it, actually, with the rule of Janet. And that would lead to chaos. Now, as far as my particular views on abortion, here's the thing. I have views on that. But our responsibility as jurists is to set those aside to do the work of the court. And that's what I've done during my time on the Supreme Court of Wisconsin. And I think you need to have a method of doing it, right? So first you recognize that you have political views. Second, you commit to setting them aside to do the work of the court. And then three, you need to have a methodology to make sure that when you're doing that work, you're squeezing out your own personal politics and views on the subject. So the way that looks, at least for me, is this. So I start out with the law that applies to the case, whether Constitution, statute, regulation, common law, whatever it might be.
Including the 1849?
Including the 1849 statute. And then you use rigorous logic to move from those premises all the way down to the conclusion. And when you're done, you should be able to look back and see an unbroken line of logic between the conclusion and the premises. And if you can, that's your guarantee that the conclusion is commanded by law rather than the individual jurist's preferences. So that's the work of a court, and I understand how to do that. I'm not entirely sure my opponent does. So, you know, I hear from some folks that they really don't like the 1849 statute. And my answer to them is, well, then talk to the legislature. They're the ones responsible for making the law, amending the law, repealing the law. And if that's what you want to address, well, then there's an entire branch of government built for that very purpose.
Extremist groups, they say, are endorsing you. They allege that. Are they?
I don't know of any extremist groups endorsing me. I do know that Pro-Life Wisconsin, Wisconsin Right to Life, and Wisconsin Family Action are endorsing me. Now, the conversations that I've had with them about this race are the same conversations I've had with everybody else in the state of Wisconsin. So I lay out for them my judicial philosophy, my understanding of how the Constitution operates, the humble role that the Constitution assigns to the judiciary, simply applying the law to the extent it's consistent with the Constitution, and that is my promise to literally everyone that I talk to those groups as well as individuals and groups all across the political spectrum. It is the same promise for everyone. And those groups said, well, that's what we want in a jurist. We want someone who will follow the law. We don't want someone who's going to go to the court and tear up the Constitution and our statutes and just start imposing that person's personal views of what the law ought to be. So so these groups are committed to the constitutional order, as I am, and so they've endorsed me.
You have been also accused of being on the payroll of a radical anti-abortion group. Is that true or false?
It's false. So first off, again, and I've said this several times, look, if you're going to lie about me, at least put some effort into it. I mean, these are such sloppy lies that not only are they not true, but they reflect really badly on my opponent. So on the question of payroll, I'm not sure my opponent knows what a payroll is. I mean, she's been a government employee, I think, pretty much her entire life. So, so just, Janet, in case you're watching, there's a difference between payroll and having clients. The Constitution requires that in order to sit on the Wisconsin Supreme Court, you have to be a lawyer. Lawyers have clients, and lawyers are not on the payroll of their clients. So I think that's one of the first things to note is that apparently she doesn't know the difference between clients, a client relationship, and an employment relationship. And then I have no idea what she's talking about when she says extremist organizations. I mean, that's I don't look at these groups and see extremism. I see groups that are they're talking about subjects about which they care a great deal. They are participating in the political process as the Constitution provides, and as long as they're doing that, this is what it means to live in a free and self-governing society. And so, with these groups, as well as all the others across the political spectrum, this is how we exercise our rights as citizens. This is how we have these conversations that we resolve in the political branch of government, the legislature, so that we can live together in peace, right? So this is, I'm deeply concerned that my opponent does not understand the fundamental purpose of a constitution and the separation of powers and why we have different branches resolving different types of questions. And it's a great and grave concern because the only way we can live together in peace is if we have an agreed upon way of working out these questions. So, clearly Wisconsin is pretty evenly divided on political questions. We need to have a place where we can work out those differences. And that place is the legislature. Now, once that's worked out, we don't rehash those conversations and debates in the courts. We just take the work product from the legislature and we use that then to resolve legal questions in the courts. This is how we live together in peace in a self-governing society. And my opponent wants to tear all that down because she doesn't like the answers coming from the legislature.
And with that, and with a major portion of the advertisements in opposition to you are dealing with the topic of abortion, giving one perhaps a picture that Dan Kelly is anti-woman. Are you?
Good Lord, no. So let's start with this. I am married to a wonderful woman for 33 years. 4 of my 5 children are daughters who I adore, and this is just between you and me now. My daughters have got me wrapped around their little fingers. So I used to be a dad that was, I had rules they had to follow, and then, things like when the doors are closed in Dad's office, then you have to wait until he's done working. My youngest in particular, she is just so gregarious and full of life and joy, and it's hard to say no. And so she comes roaring into the office, and she's already in the middle of a conversation. She wants to show something to me, and I'm just wrapped around her little finger. And I can't even imagine how someone could come to the conclusion that I am anti-woman. That is a preposterous thing to say.
I'd like to look at some of the other attacks that have come against you to have you respond to them. You're accused of defending child sex predators. They posed as ministers in order to prey on vulnerable young girls. That message is being out there repeatedly. Comment on this, if you would.
Yeah, so the ad says that I defended him at a trial, and I'm a monster for doing that. Now, here's the thing. That is, number one, it's not true. Number two, it's slanderous. So here's how this worked out. So the first law firm I worked at a law school, I was assigned the Spalding cases, and I handled a couple of pretrial matters in those cases. And then I moved to the firm where I would spend the vast majority of my career before I went to the bench. So I didn't represent them at trial, so that's a lie. But let's get to the deeper problem with that ad. So my opponent says you're a terrible person because you served as defense counsel. Well, this is how our system works. And I don't know if she knows this or not. And again, I mean, and I keep saying that, but it is just mystifying to me that that any minimally competent jurist could be saying garbage like this. So the suggestion is that if you represent a criminal defendant, you only do that because you approve of the crimes that your client is accused of committing, which is just ridiculous. And it's a slander not just against me, it's a slander against all attorneys who handle criminal defense matters. And as anyone who's ever watched a cop show knows, we have to have criminal defense attorneys because every criminal defendant is guaranteed the right to counsel. And you know what happens if you don't give them an attorney? They can't be prosecuted. And eventually they just get spun back out into the community from which they came, and it makes our communities more dangerous. So we need people taking these cases. Now, I think it is just a grossly irresponsible slander to all those people fulfilling a required constitutional role in order for our criminal justice system to work. You know, my time on the court, I understand that it's difficult getting enough attorneys to take these cases. They don't pay well. Sometimes the attorneys are actually losing money. They don't pay enough to cover their overhead. And now we have a member of the judiciary coming out and suggesting the only reason they would take these cases is because they like the crimes their clients are accused of committing. Now, what's that going to mean in a practical way? I mean, these attorneys are already, it's not financially good for them to take these cases, but if you have a member of the judiciary slandering you if you take them, who's going to want to take those cases?
Daniel Kelly with us here tonight, running for a 10-year term to the Wisconsin Supreme Court. A reminder, the Election Day is Tuesday, April 4th. Early voting is going on this week. I'd like to address one other aspect of criticism that's been launched at yourself, and that deals with the Zignego case, in which they indicate you recused yourself and then had all this money flow into you, and then you did away with your recusal, came back on the case again, and weighed in on that. Would you tell us about this, address this issue?
Yeah, so another just shocking and irresponsible and sloppy lie. So the Zignego case addressed whether local clerks or the Wisconsin Election Commission had the responsibility for cleaning up and maintaining the voter rolls. So it came to the court on, if I recall correctly, a petition to bypass the Court of Appeals. It came before the April 2020 election. So I looked at that case and I saw, well, you know, the resolution of that case could potentially affect an election in which I'm a candidate. And so I recused myself. Now, time goes on, the election comes and it goes, and then that case came back to us on a petition for review. And so I looked at it and said, well, it no longer has the potential or the capability of affecting anything in which I had an interest. And so I wrote a letter to each of the parties, and I said, all right, here's why I recused myself. That reason no longer obtains. Would anyone have an objection to me participating in the case? And no one objected. And so I participated. And the extent of my participation was this. I voted on the petition for review, and that was it. I then left the court, so I didn't hear the arguments in the case. I didn't participate in deciding the case. So this is the way that you are supposed to behave as a jurist. You are supposed to sit on every case that you possibly can, unless there's something that interferes with your ability to do that. And financial contributions to a campaign are not one of those things. And again, maybe Janet doesn't know this, so she should probably read the Code of Judicial Conduct. But our Code of Judicial Conduct says that financial contributions are not a basis for recusing from a case. You still have a duty and obligation to sit on that case. So she's just wrong as a matter of fact. She's wrong as a matter of reasoning. There is just no intelligence behind that accusation. So once again, just a sloppy, irresponsible lie. And we keep saying this, but she keeps doing it.
There's a story that came out from Wisconsin right now I'd like you to comment on. And if I could just read the opening paragraph here. It says the former stepson of Wisconsin Supreme Court candidate Janet Protasewicz alleges that Protasewicz repeatedly assaulted her then husband, his elderly father, Patrick J. Madden, by allegedly slapping Madden with an open hand so hard that she left part of a handprint on his face and aggressively pushing the 70-year-old veteran judge so forcefully that he injured his shoulder and almost fell. That's the opening paragraph. It goes on, and they've covered some other stories on this as well. You have not been out with spots pertaining to this issue or calling attention to this matter. Tell us why not, and your thoughts and what's come out here from Wisconsin right now.
Yeah, so we've had one press release that we did on this that kind of encapsulates what I think about this. I mean, they're serious allegations, and I think the people of Wisconsin deserve a response on this. But I'm not promoting these allegations. It's not something that I talk about in our ads. It's not something I talk about in my appearances as we travel around the state of Wisconsin, because they're allegations. And so careful jurists will only traffic in things that they know are true. Part of the role of a court and a jurist is to deal only with those things that we are confident are true. And these allegations, if they turn out to be true, say something pretty significant about Janet's character. But that's a big if. They might not turn out to be true. You know, there has not been a complete investigation. Wisconsin right now has started it, but there is no resolution to that. And so until those allegations are proven or disproven, I don't think it's appropriate for me as a judicial candidate to be remarking on that. Now, having said that, Janet and her allies are doing their level best to draw me into this. So let's set aside whether the allegations are true or not for a moment. Her response to these allegations is something that I think it's appropriate to remark on. So she comes out and she denies it, and then she threatens to sue her former stepchildren over these allegations. Well, this is just a wildly inappropriate thing for a jurist to do, or a judicial candidate to do. I mean, think about this. She is in a position of power and prestige and authority, and she is talking about bringing the power of the judiciary down on a single individual because he's speaking out against her in a campaign. So let's take a step back to the First Amendment and the reason that we have it. It is there, and the protections of Article 1 of the Wisconsin Constitution are there to protect broad, robust conversations, free speech, specifically about matters of government and those who are presenting themselves as candidates to serve in government. It exists for that very reason. And here's a sitting judge threatening to use the power of the judiciary to shut down someone who's saying something that she doesn't like. Well, this is not the way that we handle things. So once again, Janet, if you're listening, all these garbage, vile lies that you're spreading about me, spending millions of dollars promoting those against me. Never once have I threatened to sue you. You sure deserve it. but I would never make that kind of a threat, because that would be violative of the spirit of the First Amendment and the vigorous conversation that we're supposed to have over campaigns for state office. And so I think it would be wildly inappropriate for her to be threatening that. And then she's got her allies coming along and making it in the judiciary and calling these folks who've not inserted themselves into this debate. They were sought out. But there are others in the judiciary who are now going after them, calling them liars. And this kind of behavior it's irresponsible. It is destructive of the First Amendment and the freedoms that we are supposed to enjoy, that are supposed to be beyond question. And yet my opponent and her allies are threatening to use the power of the state to shut down somebody because they don't like what they're saying. Well, you know what? I don't like what Jan is saying about me, but I'm not threatening to use the power of the state to shut her down.
Daniel Kelly with us here tonight. Friends, we'd like to open our phone lines to give you opportunity to ask your questions on things we've talked about, other things pertaining to the campaign. Our phone number is 414-935-3030, 414-935-3030, toll free. You can reach us at 1-800-733-8830. That's 1-800-733-8830. Just encourage you to call quickly here. Time is short for this interview here tonight, and we'll take your calls. And if you'd like to text in your question this evening, you can send your first name, the city you're texting from, and text it to 414-439-3585. That's 414-439-3585. Well, waiting for the first responses to come in, I just want to ask you, you said you weren't you're not doing spots or commercials on this or anything, but yet you have been calling attention to crime in this campaign and decisions that have come from her as it relates to crime. Comment on that and contrast that with what we've just talked about.
Yeah, so this is the difference between allegations and things that are a matter of record. So I talk about the things that are a matter of record. Mm-hmm. So I talk about some of her criminal sentences because I think that's a good window into her judicial mind. Alexander Hamilton, writing 235 years ago, said that courts have neither the power of the purse nor of the sword, but merely judgment. Mm-hmm. And where you see someone's judgment who's sitting on a trial court, where you see that the most clearly is the way they handle criminal sentencing. And so that's one of the things that we've been talking about, because what I see there is a judgment that is really problematic.
How so?
So we look at some really serious crimes. So, for example, and I don't know, the age of folks that might be listening here, so I'm going to cabin in my language a little bit. So, for example, a handful of years ago, a man comes into a room where a woman is sleeping, and he proceeds to violate her in the most personal, intimate way imaginable. And it was a terrible, terrible crime. He's duly convicted, comes to my opponent for sentencing, and the victim is there to testify. And she talks about how she can't go to work anymore, and how she sobs every day, and how her closest friend abandoned her as, quote unquote, damaged goods. And after hearing all of that, my opponent looks at this guy and says, 1 year and 2 months in prison. And that's all. Now, this young lady, she's going to have to live with this the rest of her life. The guy who did this, 1 year and 2 months in prison. Now, that's bad enough. But what's really chilling is the reasoning she used to get there. So she looks at him and says, I see in you a lot of good things. To this guy who just committed this horrible crime, I see a lot of good things in you. And then she went on to say, and I don't think that you're a danger to society. After all, this was just a crime of opportunity, as if a woman asleep is simply an opportunity for a man to violate. Now, I didn't mention that the woman was his cousin. So not even being family was enough to protect her from him. And yet my opponent says, no danger to society there, which I suppose is is true, but only unless, if you're not a woman who needs to sleep from time to time, in which case, he's a horrible danger.
Right. Let's get to the phone lines. Linda is calling from Milwaukee. Hi, Linda. You're on the air.
Hi. Thanks for taking my call. Justice Kelly, can you tell me why that the one debate that was between you and Janet Protasewicz was not broadcast on any of the local news channels?
Yeah, I wish I could. We wanted to have that debate shown all over the state. There was just that one debate, and we are now 8 days from the election. Unfortunately, I'm pretty sure there aren't going to be any more debates.
You've had invitations, though, for other debates.
We have. We've received over a dozen invitations, and we've accepted every single one of them. But the only one we could convince my opponent to show up for was, a week ago Tuesday. And I think that's a travesty because she is hiding behind a pile of slickly produced ads, and she's not allowing the people of Wisconsin to see who she really is. And that's what debates do. So now, as far as coverage, that's controlled by the media themselves. They decide which TV stations are going to be there, who can carry it, who can't. So we've been doing our best to try to move that out around the state so everybody can see who Janet really is. And I think that, if they take a look at that, and it's available on YouTube, it's available, I think, Channel 3000, WIS-I, I think, has it in their archives. And I encourage everyone to take a look, see what Janet's about, because she really did reveal herself as a politician who wants to wear a black robe on the Supreme Court and nothing but a politician.
Linda, thank you so much for the call tonight.
Sure, thank you.
We've got Kelly next in Mayville. Hi, Kelly, you're on the air.
I just wanted to say, wow, I've seen some of them ads, and they make you out to be some kind of monster or something.
Yeah.
And it's not right, I don't believe. At the time, I questioned it too. I wasn't sure, and I just hope the rest of the people can see through it too and see the truth. So you got my support. That's all I got to say.
Kelly, thank you so much for that. That's one of the concerns that we have is that the millions of dollars coming in from around the country to support my opponent's lies, it makes it hard to chase down those lies because she's got so much money to spread them around. But what we've done is on our campaign website, that's justicedanielkelly.com, by the way. If you go up to the top, there's a fact check tab. And we've been tracking all the lies that my opponent tells about me, and then we're telling the truth about them.
What was the website?
JusticeDanielKelly.com. And Kelly is with one E. We like the Kellys that have two E's, but we just have the one. So JusticeDanielKelly.com. It's on your screen now. That's it. So go to the fact check tab, and you can see the sloppiness and irresponsibility of the lies that my opponent has been telling about me.
Here's a couple texts that have come in. This one from Kirk in Oak Creek. I'm voting for Dan Kelly. He says, praying that he wins, said that multi-millions were donated, given for Janet's campaign. It seems unfair.
Yeah, so one of the things, I'm not terribly concerned about the money that comes in supporting what she's saying. I detest what she's saying because they're lies. I think that especially with a judicial campaign, you have a duty to tell the truth. I think that's true across the board. But in our courts, when Hamilton said that about the only thing we have is judgment on the courts, neither the power of the person or the sword, I think it can be truly said that we are made out of nothing but words. And those words have power and efficacy only to the extent of the personal integrity of the person saying or writing them and the probity of their analysis. And so, I have no objection at all to people spending millions of dollars supporting my opponent. I just wish they were not telling lies with all of that money. Come on out, and this is my challenge once again to Janet. Come on out. Let's have a conversation about what the court actually does. Stop talking about your political values. That has nothing to do with the proper role of the court. Come out and debate me. We still got time. We got 8 days left. We can make room in the schedule for you. Let's come on out and hear what you think about what the court does. Because during this entire campaign, all you've done is talked about your politics, which is what the legislature does. And we've never heard what you think about what courts do. Come on out and talk about the Constitution, the rule of law, what it takes to be a good jurist, where the authority comes from that we use. These are the things that are relevant to a Supreme Court justice's job. How about we talk about that?
Let's get to another text. This one's more of a comment. Sean from New Berlin. I've hardly seen Mrs. Protasewicz on TV or interviews. Why has she been silent from the media, letting the ads do the work for her? We deserve to hear her message from her mouth, so he says.
Yeah, and he's absolutely right about that. Hiding behind these slickly produced ads is not giving an accurate indication of who she is. I mean, this is one of the reasons why I think it's so important to have a series of debates, have them around the state, so that everyone who's going to be voting in this election has an opportunity to see what you're about. So I invite people to go to Channel 3000 or YouTube or WISI, wherever you can find the debate, and at least have an opportunity to see her in person. And I think what you'll see there is someone who really just wants to be a legislator, but is running for the court. And that's a bad, bad combination.
Okay, we just lost a call from East Troy, but let's go to Janet in New Berlin. Hi, Janet, you're on the air.
Good evening, Your Honor. I have already voted for you.
Thank you.
And the question is, why can't you make commercials where you are the person speaking with some of the things you're telling us right now?
Yeah, that's a great question. And so it has to do with the amount of resources we have available to us. Right now, the Code of Judicial Conduct says I can't ask for contributions, but it is a simple fact of life that our ability to produce and air commercials depends on how much we have in resources. And so, my opponent is getting just an enormous sum of money from around the country. And so she gets to produce a lot of slickly produced ads that she can hide behind. But we have a limit because of the amount of resources we have in doing in being able to approach the people of Wisconsin in that way. So we do have some ads that started. It would have been this past weekend, and some of those do address this. Now, they're like 30-second chunks, right? There's not a lot you can say in 30 seconds, as it turns out. And my campaign keeps telling me that I need to learn how to speak in shorter sentences and shorter sound bites. But I don't think that's ever going to happen.
Let's go to Irwin in Milwaukee. Hi, Irwin, you're on the air.
Yes, Justice Kelly, I've seen quite a few of Janet Protasewicz's ads, and in numbers of them, she says that she's been on the bench for 20-some years, and she has sentenced tens of thousands, she says, of convicts, of criminals, and the ads that were shown were only certain snippets or certain ones that were chosen, and she says that is not representative of her rulings. Could you please comment on that?
Sure. Yeah. Obviously, we don't have enough time to go through all of the sentences that she's imposed, and I'm presuming that at least some of them are okay. But here's the real issue. Look at how she responds when I call her out on these sentences. So if you watch the debate, you'll see something I think that is really instructive. So I went through some of those cases, and then her response to that was to lie about what she did. So I gave the rationale that she used in coming to the sentencing decisions, and she says, I never said that. And she says, I want a fact check on what Justice Kelly is saying. And so someone, turns out, did that very thing for her, put together a video, a fact check. And so it shows her asking for the fact check. It shows me saying what I did, her saying that's a lie. And then immediately what comes up is the transcript from the sentencing hearing that says exactly what I said that she said. So her response to these is not really to say, well, look, there are legitimate reasons for why I did what I did. Her response is to lie about it. Now, that's what happened at the debate. But she's also been called out about this before. There was a show she was on, I can't remember which one it was, but she was asked about some of these problematic sentences that she has imposed. And she was asked if she, in retrospect, regrets any of those sentences. And her response was to laugh off the question. So if the sentences themselves were not problematic enough, lying about what she said about the sentences was really problematic, and then laughing off the sentences themselves, I think it shows a judgment that is just broken.
We've got a lot of people lined up here,
right.
So we're going to have you shorten those responses here in just a bit. This is Todd from Plymouth. Is there anything you can do as a Supreme Court justice to fix voter fraud in Wisconsin?
Yeah, the only thing that we can do is enforce the law as is written, right? So now, as an example of that, though, just this past term, the Supreme Court addressed the question of whether ballot drop boxes were available to use and whether ballot harvesting is allowed by our statutes. And the Supreme Court looked at that and said, well, we don't see anything in the statutes that allow for ballot drop boxes, and there's nothing in there that allows for ballot harvesting. Mm-hmm. So you cannot do those things. But that's the limit of what the court can do. It can't prospectively go out and say, you know, we see these things that are happening and they shouldn't, and so we're going to go after those. The only thing we do on the court is resolve legal questions presented to us in an actual case.
So it's a legislative fix.
It's a legislative fix.
Let's go to Lowell in Menominee Falls. Hi, Lowell. You're on the air.
Hi. I just wanted to ask or comment to the wonderful justice that if there's a heartbeat going on in a woman's womb, who has the right to terminate it using the word rights? I mean, how can rights trump murder?
Thank you,
yes. Thanks, Lowell.
Because you can't snuff out the heartbeat just because you think you have a right to do it. No one has a right to kill a child, an unborn child.
Thank you, Lowell. We're going to have the justice respond.
Yeah, so these are conversations that we have in the legislature, right? And when I say we, I mean we, the people of Wisconsin. So that's where we take our political questions to get them resolved. And then those of us in the court, we then take that work product and we use that to resolve the cases. And so the role of the court can sometimes be really difficult because you might not like the law, and yet your obligation is still the same every single day. To apply that law with neither fear nor favor for any person or position. So for those who are passionate about the question of abortion and whether it should or should not be allowed, that's a conversation to be having with the legislature.
We've got Richard in Oconomowoc next. Hi, Richard. You're on the air.
Thank you for taking my call. We, as a family, are praying for you.
Thank
and
you.
At the same time, we're all going to vote for you. And I thank you for your integrity, standing above your opponent, because I feel that the person that's throwing the mud is losing ground, in my opinion. So I thank you for standing above your opponent and being the sincere person that you are. So God bless you.
Thank you, Richard.
Well, Richard, thank you so much for that. And thank you especially for your prayers. As you might imagine, it's a difficult thing to do this, going around the state and doing it. Especially for an introvert like me. I'm most comfortable in Supreme Court chambers, reading, writing, researching, and so I really appreciate your prayers. I learned a long, long time ago that there is strength and wisdom and peace in prayer, and I could use all of that I could possibly give. So thank you so much for your prayers.
We're going to be turning back the phone lines now because we've got several texts. We'll have you respond here in our final minutes. This is Luann from Racine. It says that Janet ads say that you never convicted anyone. Could you please address this?
Yeah. So I've never convicted anyone because I was not a trial court judge. I've been a Supreme Court justice. I've been a lawyer for a long, long time prior to that, and I've had a broad array of practice. Most of my work was done in commercial litigation, but I've also served as a special prosecutor. I have done some criminal defense work. I've done governmental affairs work. And so the most important thing for a Supreme Court justice is not that he has experience convicting anyone, it's that you have a deep and abiding commitment to the rule of law and doing what the Constitution has required of you. So on the Supreme Court, we don't actually convict anyone there. We are reviewing discrete questions. And so, whether you have experience in the past in a trial court, that's not necessarily relevant to the work of the Supreme Court, because we do very different things, and it's why we have different courts, because they have different functions.
Shannon in Oak Creek is next here and says, I too am voting for Dan Kelly. The thing that upsets me most is Janet promised on an NPR radio program to give Tony Evers the power of the pen to restrict what you care. Would you care to comment on that?
The power of the pen
to Tony Evers.
I'm not entirely sure what she's asking. I'm sorry. She promised to give him the power to do what?
That she promised to give Tony Evers the power of the pen. I'm sorry, to redistrict.
Ah, that's it. Okay, got it. Yeah, I mean, what Janet said about redistricting is, again, emblematic of the fact that she's not really a jurist. She's a politician who dresses up like a judge, but she's not really a judge. So she's been going around the state saying, those maps are rigged, they're unfair, and they need to be fixed in the courts. And that's not where we have our political conversation. So a districting map is almost entirely a political exercise, deciding where the lines are going to go, which communities are going to get lumped together in a district. That's a political question. So we leave that to the legislature to do. Now, there are legal requirements, and those can be brought to the court for determination, but that doesn't have anything to do with the distribution of political power amongst those districts. So we look at, for example, Article 4, Section 4 of our Constitution says that our districts have to be reasonably compact. They have to be comprised, contiguous territory. They have to be bounded by certain municipal lines. And of course, they have to follow the Voting Rights Act. So these are legal questions, and therefore, because they're legal, the court can address them. But the question of the political distribution of power around the state, that's political, and that has to be resolved in the legislature.
So we're going to have to leave that there.
All right.
And we've got more that we're not going to get to here this evening. Justice Daniel Kelly with us. We have just 60 seconds left. What would you like to leave with the viewers?
Well, I want to thank him so much for spending some time with us this evening. And I want to ask him a couple of things. One, to exercise their authority and responsibility in deciding who's going to serve them on their Supreme Court. And then, if I could, to ask for their continued prayers as we go through this last 8 days. Pray for wisdom for us and for strength, and I would so much appreciate that.
Great. And again, your website to leave with viewers?
JusticeDanielKelly.com.
Very good. Thank you for being with us tonight.
Thank you, Jim.
And friends, just a reminder that Tuesday, April 4th is Election Day. Early voting can be done yet this very week. Check with your municipality to find out where and what times are available for that. But always here at WVCY, we encourage you, number one, to be informed, and then to cast a prayerful vote as you go to the polls on Election Day. A very critical election. Much is going to be determined by this election. The impact of this election is going to hit this state for generations to come. Good night. May God richly bless you.